Okay, we're going live. We're reading the actual mini outline, not like a 100-page outline for remedies. That's apparently what we're supposed to be reading. Get moving along. Remedies, California Overview. In brief, always look for available remedies in this order: damages, money stemming from tort or breach of contract, restitution, money stemming from unjust enrichment, injunction, equitable order to refrain from doing something is a negative injunction, or to do something is mandatory or affirmative injunction. In contract, this is usually a specific performance decree. Tort remedies. Compensatory damages compensate the plaintiff for loss or injury. So we're entering torts, remember. Compensatory damages, loss and injury. There's general damages, which compensate foreseeable losses. Special damages compensate unforeseeable losses and must be specifically pled. Nominal damages are often recoverable when no actual injury is sustained. Punitive damages may be awarded to punish a defendant for willful, wanton, and malicious conduct. Interest and attorney's fees. A, awards of prejudgment interest are usually statutory. B, attorney's fees are generally not recoverable absent a statute or contract. Right, so that's your interest and your attorney's fees. Prejudgment interest that's statutory can be awarded. Attorney's fees are generally not recoverable unless they're specified in statute. Restitutionary remedies. Restitutionary damages obligate the defendant to pay the plaintiff the reasonable value of a benefit unjustly obtained. This can take the form of an action in quasi-contract. Replevin permits a plaintiff to recover before trial possession of specific chattel wrongly taken or detained. Ejectment is a legal remedy to restore possession of real property from which plaintiff was wrongly ousted. Constructive trust. Equity creates a trust to compel defendant to reconvey title to property unjustly retained. Equitable lien, a lien imposed on defendant's property to secure payment of a debt owed to plaintiff. Those are all the restitutionary remedies. There's 5. Just to remind you what's in the beginning. What is the definition? Is that restitutionary damages obligate the defendant to pay the plaintiff the reasonable value of the benefit unjustly obtained. This can take the form of an action in quasi-contract, and they start with replevin, ejectment, constructive trust, equitable lien. There's some interesting caveats to constructive trust and equitable lien that are really just not discussed in this outline. So, one, the constructive trust, they got that right. It creates a trust to compel the defendant to reconvey title to property unjustly retained. But I'm looking up in my outline, basically in the professor's outline for remedies, some specific information about maybe not the constructive trust, but the equitable lien. So here we go. Constructive trust is a remedy when there's tortious conduct by the defendant, for example, embezzlement, not by a stranger, because of tracing. Theory when no community assets to provide. I don't know. Some of that I kind of trailed off. But the traceability aspect, you can trace what was taken to where it was spent. That's a necessary requirement of constructive trust. An accounting exercise to determine your money as differentiated from money of the defendant and traced to the purchase of an asset, let's say. Ask the court to impose a constructive trust on traced new asset as to the asset defendant did not already own. Now, this is a legal fiction because The defendant did not create a trust for the benefit of the plaintiff, but justice provides that. Like I said, it requires a relationship between the parties. And I don't know what confidential fiduciary means, but for a court, trust res has to be identifiable and severable, which is going back to being able to trace it to the purchase of a new asset. And in this recovery, you get the entire asset, including any increase or decrease in value, and it equals your entire recovery. There's no deficiency judgment available. So the equitable lien, not much more to read about the equitable lien. What Barbri says is it's a lien imposed on defendant's property to secure payment of a debt owed to the plaintiff. I think there's serious traceability caveats that Barbri didn't recognize. Here's procedures. Determine a cause of action, such as nuisance, trespass, violation of permit requirement, file a complaint, and notice/serve the defendant seeking temporary protective restraint. Wait. Sorry, I just read. That's about all equitable remedies. We're talking about equitable lien right now. Apologies. So for the equitable lien, is a remedy where the court imposes a security interest on an item defendant already owned. So this isn't one that was purchased with the ill-gotten gains. This is one the defendant already owned, but he used the ill-gotten gain taken by the tortious conduct to improve personal property, such as an antique car. Maybe the amount that was taken, like $5,000, was used directly to redo the upholstery of the car, or a house. The money from the tortious conduct was used to install a pool. Now, the plaintiff does not get the entire asset, just a security interest that has priority over other judgment liens other than those secured by the item already, such as a mortgage or a home equity loan, and puts the plaintiff in the secured category if the defendant files for bankruptcy. This is one that has to be requested in the pleadings. Not very often applied, but the bar examiners like to test on it. The plaintiff will have to wait to collect and cannot force a foreclosure. So that's the equitable remedies that, such as constructive trust and equitable lien, that I think matter. So as I'm reading it now, no, the equitable lien doesn't seem to need. I guess you need to be able to trace it to improvement of the defendant's property that they own, but traceability is absolutely a requirement under the constructive trust theory of recovery. So going on is the injunctive relief in tort may be granted if legal remedy is inadequate, which means money damages will not make the plaintiff whole, and damages are highly speculative. That's not like a requirement. That's just kind of part B under the idea that the legal remedy must be inadequate. And two, the decree can be enforced. Like enforceability is not an issue, and the hardship to the defendant or the public does not outweigh the benefit to the plaintiff. Fourth, there are no defenses. We'll go into what those defenses are. And fifth, interlocutory injunctions are used to preserve the status quo until the trial on the merits can be heard. So for defenses, the three that apply to injunctive relief for tort are laches, unclean hands, and freedom of speech, which is a defense to, say, for instance, defamation. Perhaps I'm filing an injunction to stop New York Times from publishing, confidential CIA papers. Is it their freedom of speech to publish that? If so, that could be a defense. Latches, a plaintiff has unreasonably delayed asserting an equitable claim, and the delay has resulted in prejudice to the defendant. And unclean hands, the plaintiff is guilty of inequitable or wrongful conduct with respect to the transaction at issue. Moving on, the application of remedies to specific torts. Oh, wait, did I read? Interlocutory judgments are used to preserve the status quo until the trial and the merits can be held. So, A and B, A, you must show the likelihood of prevailing on the merits, and B, you must show that absent the interlocutory injunction, irreparable injury will result before the trial can be held. Okay. D, the application of remedies to specific torts, misappropriation of money. To recover money damages, the plaintiff may bring an action for conversion. B, restitutionary measures, a quasi-contract remedy. An alternative to tort is an equitable remedy imposed by courts to avoid unjust enrichment by ordering that the value of an unjustly obtained benefit be transferred to the plaintiff. The plaintiff need only show the defendant was unjustly enriched and the plaintiff is justly entitled to the benefit. Now, 2, constructive trust. The stolen property must be specifically identified and traced to the possession of the wrongdoer. Yeah, that's what we were talking about. 3rd, equitable lien. This is all when there's a misappropriation of money. So basically restating the damages in order of when you would apply them. For the equitable lien, like we just discussed, if a constructive trust cannot be imposed because title was not acquired with the stolen property, but the misappropriated money can be tracing to an improvement on property, an equitable lien may be imposed on the property. 2, remedies for injuries to personal property. So this is the second tort applicability, and we're going to apply the potential damages to remedies for injuries to personal property. Now, if there's a destruction of chattels, the plaintiff may recover the value of the chattel at the time of destruction, less salvage, plus interest. Injury to chattels, plaintiff may recover the diminution in value to the chattel or the cost of repair. Dispossession of chattels. Conversion damages is an appropriate remedy only if the disposition causes substantial interference with the plaintiff's ownership rights. And A, damages are measured by the market value of the property at the time of conversion plus interest. B, plaintiff may recover fair compensation for time and monies properly expended in pursuit of the property. So that's one I haven't argued before. So that's when you're dispossessed of your chattel. Remember, conversion damages is an appropriate remedy only if the disposition causes substantial interference with the plaintiff's ownership rights. I always thought it meant total destruction, but it doesn't. I also remember in the MBE question when the neighbor broke the leaf blower that you could buy new for $500 or get a substitute used leaf blower for $300, that the recovery was actually $300, which is in keeping with what is being said in A under conversion, that the damages are measured by the market value of the property at the time of the conversion, plus interest. So the market value is what the market will bear, not necessarily, I guess, a windfall of buying a new chattel. So, secondarily, under disposition of chattels, alternatively, the plaintiff may seek restitutionary remedies, including self-help, McLevin, quasi-contract, constructive trust, and equitable liens. Remedies for injuries to real property. Trespass to land. No physical injury results to the realty from a simple trespass, but the plaintiff may recover nominal damages. Trespass causing severance. Right, no physical injury results to the realty from a simple trespass, but plaintiff may recover nominal damages. When a trespass causes severance, damages, restitutionary remedies, and injunctive relief appear to be available. When trespass causes other injury, damages and injunctive relief are available. And when a trespass affects an ouster, then ejectment and mezzanine damages, which is the rental value for the period the land is occupied by the trespasser, are available to the plaintiff. Encroachment is another injury to real property. Damages, ejectment, and injunction are listed for encroachment. And destruction of or injury to realty. Remedy is the difference between the value of the land before and after the injury. For destruction of or interference with easements, the damages and injunctive relief are available. For waste, damages and injunctive relief are available, and the same is available for nuisance. Now we're moving on to a new section of tort for remedies for injuries to personal interests. And personal injuries, one, there's no restitutionary remedies and injunctive relief is rarely sought. Damages, economic losses, special damages include medical expenses and loss of earnings, past and future. To be under the damages for personal injuries is non-economic losses, which are referred to as general damages, which include pain and suffering, emotional anguish, loss of enjoyment of life. Survival of tort actions based on statute, and also damages accrue to the decedent up to the time of death. So you got like wrongful death and survival statutes. Not really a lot being discussed in that section, but really complicated. So maybe let's read what Barbri says, because I don't know if I'm going to be able to find it easily on, paging through my outline for like wrongful death and survival statutes. One thing, there's quantum merit. There's the word I was looking for. All right. I'll find it in this remedies outline just by searching the word survival and tort actions and wrongful death. Okay, these are both on page 30, so they're all on the same page. This won't be too bad. Okay, wrongful death is discussed in the torts outline. Survival of tort actions. Most jurisdictions have survival statutes whereby a decedent's estate can sue for personal injury damages accrued to the decedent up to the time of death. I was telling us to look at tort. I so happen to have torts here. Torts. I don't recall it being at the end. Maybe not. Survival and wrongful death, page 50. All right. Survival Act allow one's cause of action to survive the death of one or more of the parties. The acts apply to actions involving torts to property and torts resulting in personal injury. However, torts invading intangible personal interests, for example, defamation, invasion of right of privacy, malicious prosecution, expire upon the victim's death. That would be invasions of intangible personal interests. For wrongful death, acts like statutes grant recovery for pecuniary injury resulting to the spouse and next of kin. The decedent's creditors have no claim against the amount awarded. Recovery is allowed only to the extent that the deceased could have recovered in an action had he lived. Hence, the decedent's contributory negligence reduces the wrongful death recovery and comparative negligence states. Similarly, a potential beneficiary's contributory negligence reduces her share of the recovery, and comparative negligence states. tortious interferences with family relationships. I want to read this because it does talk about like loss of consortium, which between husband and wife, either spouse may bring an action for indirect interference with consortium and services caused by defendant's intentional or negligent tortious conduct against the other spouse. In parent and child, a parent may maintain an action for loss of child services and consortium as a result of defendant's tortious conduct, whether intentional or negligent. A child, however, has no action in most states against one who tortiously injures the parents. The word society, I remember being one that might be available to the husband and wife actions, like loss of society, might be a synonym for consortium. Nature of actions for interference with family relationships are derivative. Hence, any defense that would reduce a bar recovery by the injured family member also reduces or bars recovery for interference with the family relationship. I don't know if that one's gonna come over from the mini outline that I'm reading for remedies, so I thought I'd go into that. But I want to go back to where we were. Defamation and privacy are the last parts of the injuries to personal interest. They're very short. Defamation, there's no restitutionary remedies and generally no injunctive relief. For privacy, there's damages and injunctive relief available. So why is damages so shorted? So I think it was not too far off from what I was just reading. Maybe it was. Okay, here's nuisance. So nuisance, the damages, plaintiff will usually be awarded damages, injunctive relief. If the legal remedy of damages is unavailable or inadequate, and that's money damages, then the nuisance will cause irreparable injury, for example. Injunctive relief will be awarded. In this case, the court will consider the relative hardships. However, hardships will not be balanced where defendant's conduct was willful. Self-help abatement in private nuisance is available after the defendant and to the defendant and his refusal to act. Only necessary force may be used. In public nuisance cases, only a public authority or private party who has suffered some unique damage can seek an injunction or abatement. That's kind of what's under remedies in the nuisance section. The defamation section is actually, I think, well before this section, because I have to skip through negligence and strict liability to get to it, if I'm not mistaken. But if our Barbri, like our remedies outline says that there's no restitutionary remedies and generally no injunctive relief. Well, I think to say that more properly, you would have to determine who the plaintiff is that's being defamed. If it's a public official or public figure and plaintiff has proven fault, which is actual malice, knowledge of falsity, or reckless disregard as a falsity or truth, then the damage recoverable is, under common law rules, is presumed. And so damages are presumed, and punitive damages are available where appropriate. But if the plaintiff being defamed is a private person and the matter is of a public concern, the burden that needs to be shown is negligence as to this statement, the published statement's truth or falsity. Once that's proven, damages only for proved actual injury if the plaintiff proves actual malice. Presumed and punitive damages may be available. And for a private person in a matter of private concern, no fault as to truth or falsity needs to be proved unless required by state law. Again, damages are presumed under the common law rules and punitive damages where appropriate. So, I mean, presuming damages, like what exactly does that mean? Presumed damages, I think that means that you just don't have to, like, itemize them. But if there's damage to the plaintiff's reputation... okay, so here's another one. If you have a per se defamation, damages are presumed, which means that the defendant is liable, right? But if you don't have a per se defamation, then the plaintiff will show special damages, pecuniary damages. So, not sure I can exactly put a number to what presumed damages means. Like what, with like specific damage. I feel like in real life, the plaintiff is gonna still itemize their damages even if they are presumed. So I don't know if it matters, but I'm gonna move on to fraud, which is actually outside of the section remedies for injuries and to personal interests. So for fraud, a plaintiff must show actual injury. Consequential damages may also be recovered. Punitive damages are recovered if malice is shown. Remedies include damages, rescission, and constructive trust. Now, business torts is the next section, including breach of contract. Remedies include damages, restitutionary remedies, and injunctive relief. Interference with prospective advantage, where a plaintiff has been deprived of an expectancy but not of an actual property or property right. Damages may be unavailable because they are uncertain. Although loss from an expectancy might be uncertain, if the defendant's conduct provided him a benefit, the plaintiff may compel the defendant to turn over that benefit. Trade libel. Special damages must be pled. And majority of courts will grant injunctive relief if trade libel occurs in conjunction with another enjoinable tort. Contract remedies. So we're halfway through this remedy discussion, and we just wrapped up tort remedies. Now I'm going to talk about the types of damages available for contract breach. Compensatory damages that put the plaintiff in as good a position as the defendant had performed the contract. Punitive damages are generally not recoverable in contract actions. Prejudgment interest is available as a matter of law if the claim is for a sum certain and is discretionary on other claims. Attorney's fees generally may not be awarded unless provided by statute. Restitutionary remedy, quasi-contract. Grounds for the remedy. The most common situations for unjust enrichment may be found when the defendant has received benefits by mistake prior to a material breach of contract or pursuant to performance of an unenforceable contract. And 2, material breach of contract is another place in which restitutionary remedy might be applied, where a contract has been materially breached by one party. The other party has a right to restitution of the benefit conferred. Generally, the plaintiff is entitled to recover the value of the performance. On enforceable contracts, the restitutionary remedy depends on the nature of the benefit conferred. If tangible property has been transferred, specific restitution is an appropriate remedy. If services have been performed on materials furnished, generally recovery is measured by the value of the goods and services. So the big sections I just read there under restitution or remedy are material breach of contract and unenforceable contracts. What's happening is there's unjust enrichment, where the defendant received benefits by mistake, and like I just said, material breach or performance of an unenforceable contract. That's a highlight of what's being said here. Specific performance. There must be a valid contract between the parties. Generally, the plaintiff will not be able to obtain specific performance unless she has fulfilled all of the contract conditions or is ready and able to perform. The legal remedy must be inadequate, enforcement must be feasible, and the defendant must not have any viable defenses, including the following: latches, unclean hands, hardship, that's like the balancing of hardship, I think, and mistakes and misrepresentation, or just defendant hardship, usually comparatively. So anyway, let's just read the specific performance one more time because these really have to be memorized. If there must be a valid contract, the plaintiff must be able to perform, the legal remedy must be inadequate, enforceability must be feasible, the defendant must not have any viable defenses. So going back to these mnemonics, the mnemonic was cha-cha is fairly difficult because contract is the C, valid contract. Conditions are fulfilled is how they termed that the plaintiff is ready and able to, ready and able to perform, say for instance, the contract's conditions. Cha-cha is I, inadequate legal remedy, fairly, I have foreseeability of enforcement, but I think what I mean to say is feasibility of enforcement. Cha-cha is fairly difficult, and D is the absence of defenses. So try to remember that the cha-cha is fairly difficult. Other mnemonics, like for instance, an injunction, I'm feeling bold and determined. So for the injunction, it's probably going to apply for both contracts and tort. I'm feeling bold and determined. I'm is irreparable harm. F in feeling stands for the feasibility of enforcement. Bold stands for the balance of the hardship, and determined is defenses such as unclean hands, latches, impossibility, and free speech. So this is like the first thing we talked about in this outline. The other mnemonics we learned was like good dog and very good dog. And that's in rescission. So we're going to get to that soon. Rescission requires grounds and no defenses. The grounds are mistake, misrepresentation, undue influence, coercion, incapacity, and no consideration or illegality. Relevant. And then very good dog is for reformation because you first need to have a valid contract, whereas rescission you didn't need to. But everything else in the good dog part of the mnemonic, again, is your grounds and your lack of defenses, which defenses are unclean hands, latches, and negligence. And your grounds is mistake, misrepresentation, undue influence, coercion, incapacity, and no consideration or illegality. So, I just finished the cha-cha is fairly difficult. Valid contract, plaintiff can perform conditions. Legal remedy is inadequate. Enforceability must be feasible. And the defendant must not have any viable defenses, including latches, unclean hands, hardship, or mistakes and misrepresentation. Rescission. Rescission restores a plaintiff to the status quo before the contract. Grounds for rescission must have occurred at or before the time the contract was entered. the three things written here are mutual mistake, unilateral mistake, and misrepresentation. Again, there's grounds. Those are the grounds. I wrote down more, but the other element is the absence of the defenses, which include latches and unclean hands. And oddly, there's an election of remedies within the defense section, which says prevents the plaintiff from seeking damages for fraud and then seeking rescission based on the fraud because the two remedies are inconsistent. And under Article 2 of the UCC, a plaintiff may seek rescission and damages in the alternative. C, under defenses, a plaintiff may be stopped from pursuing rescission if the contract is affirmed after facts justifying rescission are known. Cancellation of a written instrument may be affected. This is under rescission as well. Effectual cancellation of a written instrument where it is void or voidable to the person seeking cancellation, and there is reasonable apprehension that if the instrument is left outstanding, it may cause serious injury. Reformation. A court modifies or alters a written instrument to make it conform to the party's previous understanding or agreement. There must be a valid original contract. Grounds for reformation: mistake of fact, whether mutual or unilateral, mistake of law, fraud, and the defenses or absence thereof is latches, sale to a bona fide purchaser. And fifth is interlocutory injunctions are available, as in tort actions. So, like, a lot of this is kind of inconsistent with the notes I took during the Barbri lecture. And yet I know they were using the same materials. So I'm going to enter these in my outline quickly because I just don't have them. What was different about rescission? Yeah, the cancellation of an instrument. I didn't really hear anything about that. This election of remedies is a defense. So it's just like an unfair combination of remedies. Need another pen. That's what it is, like for fraud, i.e. fraud plus rescission. In Reformation, they kind of ended the defenses at latches and they added sale to bona fide purchaser. And then there's this interlocutory injunctions. Under Reformation. All right, so that's some things to consider. Application of remedies to particular types of contracts. Contracts to buy and sell personal property. A, damages. B, specific performance if chattel is unique or damages are highly speculative. 2, contracts to buy and sell real property. A, damages. B, restitution. C, specific performance or partial performance with abatement in some cases if full performance cannot be completed. That's your contracts to buy and sell real property. You've got damages. I don't know where restitution is going to come from, but then you've also got specific performance or partial performance with abatement in some cases if full performance cannot be completed. For instance, they don't have 2 acres that they told you they were selling to you but aren't in the deed. So you might be able to just proceed, but with an abatement to the price, perhaps, which I think is a little bit nuts because I do believe that's an unmarketable deed. And so how much of an abatement are we talking? Because that's a pretty significant problem. Even if it's like 0.1 acre, it's not conforming. Anyway, where did I leave off? Okay, construction contracts, the applicable remedies when we're talking breaches to construction contracts actually has to be divided into whether the owner breaches or the builder breaches. When the owner breaches, one, damages available if the contract is wholly executory. Damages are measured by the builder's lost profits. If the contract is fully performed, damages are the contract price plus interest. And third, if the contract is partially performed, damages are measured by deducting from the contract price the cost of completing the contract, or by deducting from the contract price the total cost of performance and adding the cost of partial performance. So I'm going to read this again just because it's incredibly important, and it might be different than the cases more historical to this that I have read in class. So when the owner breaches construction contracts, if the contract is wholly executory, damages are based on the builder's lost profits. All right, so probably a better way to say this is that the builder's suing the owner for a breach. If the contract is wholly executory, damages are measured by the builder's lost profits. 2, if the contract is fully performed, damages are the contract price plus interest. And 3, if the contract is partially performed, damages are measured by deducting from the contract price the cost of completing the contract, or by deducting from the contract price the total cost of performing and adding the cost of partial performance. So I guess that or is kind of important, because I would more so lean towards taking the contract price, subtracting the total cost of performance, and adding the cost of partial performance. But before that, for these partially performed contracts, the other method is starting with the contract price, deducting the damages, which is written here as damages are measured by deducting from the contract price the cost of completing the contract. So take the contract price, you subtract the cost of completing the contract. Say, for instance, to the owner. So we're just sort of like, hypothetically, I think when that's going to be applied is when there's a cross complaint. So let's go into when the builder breaches and the owner is suing the builder. There's only 2 write-outs here. If the builder is substantially performed, damages are the cost of repair or replacement to meet contract specifications, or the difference in the building value as built and its value had it been constructed per the contract specifications. 2, the builder has abandoned the contract and is in material breach. Damages are measured by what the owner must pay to have the construction completed, anything owed to the builder, plus compensation for delay. Restitutionary remedies. Where the owner repudiates the contract after a partial performance, the builder may elect to rescind the contract and sue in quasi-contract for the value of the benefit conferred, even if that is above the contract price. Where the builder has materially breached the contract, courts generally permit restitution. So that's counterintuitive, but anyway. It's kind of like the pipe case. I don't know if that was a tort. or if it was contract, so I can't really look it up right this there isn't what the name of that case was. I believe it was like Justice Holmes' decision, and like the owner asked for a specific brand of plumbing to be used. The contractor put in a different brand, and so your damages, like even though the builder materially breached, the courts are still going to permit restitution. That they're not maybe that's not a good example, but let's just say that there is an argument for restitution under that hypothetical. The builder will be entitled to payment for his work, right? So even though he put in the wrong plumbing, he did work. He conferred a benefit on the defendant, and therefore the defendant still has to pay him for the wrong pipe, basically. So that example does work. Specific performance. Modern courts will decree specific performance when there is no adequate remedy at law, which is rare for a building contract, construction contract. But we're going to move to the next section, which is personal service contracts. First section is damages. When an employee breaches, damages is the cost of obtaining services equivalent to those promised. And 2, when an employer breaches, damages is the total wages due or promised less the amount earned or that could have been earned. Employer must prove similar suitable work was available in the locale. So those are the damages. Obtaining services equivalent to those promised by the employee is available to the employer. When the employer breaches, on the other hand, the damages are the total wages due or promised less the amount earned that could have been earned. Employer must prove suitable work was available in the locale. So damages owed to the employee are the total wages due or promised less the amount earned or that could have been earned. If the employee saw it, similar suitable work available in the locale, and that burden is on the employer to show there were other opportunities that the employee could have sought to remedy its damages. Restitution. Where an employer breaches, the employee may elect a restitutionary remedy and sue for the reasonable value of the services rendered. Where an employee breaches, the employer may rescind and seek restitution of wages paid but not earned. Third, an employee who materially breaches may be able to recover the value of the benefit conferred, subject to the offset for the employer's damages. So where an employer breaches, the employee may elect a restitutionary remedy and sue for the reasonable value of the services rendered. Where the employee breaches, the employer may rescind and seek restitution of wages paid but not earned. And an employee who materially breaches may be able to recover the value of the benefit conferred, subject to an offset for the employer's damages. Specific performance. If the services are unique, the legal remedy would be inadequate, but a court will nevertheless refuse to grant specific performance because it's infeasible to enforce. The 13th Amendment prohibits involuntary servitude, and thus it is hard to supervise. Two parties that recently went to court against one another in an employer-employee type relationship. Now, second, under specific performance, equity may specifically enforce an employee's promise not to work for anyone else during the term of employment. This would be a negative covenant in the contract by enjoining the employee from accepting other employment. Covenants not to compete. Equity will enjoin a breach of a covenant not to compete, provided the services are unique and the restriction is reasonable as to the geographical location and duration. So, that's the end of the Barbri outline with a couple of supplements from my studies. I'm going to end this recording here.